Staying with legal matters, the 50-50 split in the National Assembly's 400 seats has dominated proceedings into the constitutionality of the Electoral Amendment Act. One of the applicants, the Independent Candidates Association of South Africa, has challenged the new system of representation. The Amended Act splits the 400 seats in the National Assembly in half, 200 regional seats and 200 compensatory seats. Counsel, on behalf of the ICA, has argued before the Apex Court that there is no justification for the 50-50 split, as it disadvantages independent candidates by increasing their quota to gain a seat in the National Assembly. Parliament, however, submits that it serves a legitimate purpose.
We've provided a fairly detailed explanation as to where it comes from, but for present purposes, if I could perhaps just underscore the following. The first is that the compensatory seats and the regional seats serve entirely different purposes. And the compensatory seats, its common cause in this matter, and Mr. Atkins accepts, serve to protect against a distortion of proportionality. The second point is that it is accepted that on the 200-200 split, there is no risk of overhang.
All right, apologies about that. SABC senior reporter Canny Maphanga has been tracking this particular story for us and joins us live now. It's always interesting to have you in studio as we sit and chat together, because it feels like I'm speaking to myself, as people always say that, we look so much alike. But Canny, one of the other things that is very clear in this particular matter is that this issue of a threshold is big. I mean, today, listening to the 15% of the votes that, the independent candidates are talking about, and they're saying that for them, this is yet another barrier to entry. Let's talk about the arguments in that regard and the limitations that are being posed.
Well, indeed, Bungi, it's quite a difficult position for all parties and a frustrating matter. You've got the One SA movement, which is the second applicant that is essentially raising this issue of the 15% threshold, along with the friend of the court, that is the Rivonia Circle, that was admitted prior to the hearing. So the issue is that if you measure this 15% against the quota, independent candidates would have to get up to 14,000 signatures just for them to contest. Now, there are multiple arguments to this from various different parties in this matter. The IEC in the state, of course, is saying that because we now have this new entrance, and this is the first time that we're going to see the independents contest the national and provincial elections, with 2024 just around the corner. You have to measure it to make sure that those that make it onto the ballot are actually serious contenders. So they try to get this requirement of the 14,000 signatures in order to meet a threshold, which will say that these candidates can make it onto that ballot. Now, of course, you may know that independents can't exist within a political party. They don't have those resources, they don't have that structure, they don't have that support that you would have, for example, to launch a campaign to go from door to door to get those signatures, for an example. So they're saying that it's an impermissible barrier to entry. Most independents will feel like, why should I bother if the threshold is so high for me to contest the general elections?
And I suppose it's quite a difficult one, because even the Home Affairs arguing that they've not proven that they will not be able to get these particular signatures. But I suppose, like we were saying yesterday, it also speaks to the secrecy of the process. It speaks to exactly how does all of this then begin to unfold, because effectively you are now going to people, you are collecting signatures. What does it say then about the secrecy as well?
Well, the difficulty here is that we are dealing with a situation where we will see it for the first time in the 2024 national provincial elections. So there's actually no evidence or any data to show that an independent won't be able to get those 14,000 signatures, or they won't be able to get those required votes in order to get a seat in the national provincial assembly. So that is the dilemma for the Constitutional Court, because they have to decide on this matter and decide on the constitutionality of these amendments when we haven't actually seen any of this play out in any election yet, because 2024 is just around the corner. So I think that is the biggest dilemma that is facing the Constitutional Court right now as they battle over this threshold issue. But they're stating that this is to safeguard free and fair elections, but of course independents will feel differently. They would feel that they would need to have a fair an equal chance to contest. And by creating these new requirements, they feel that this is a barrier to entry for contestation with respect to them.
And it's interesting because the test for these electoral systems, as you say, comes before they're even put to the test during an election. But at the same time, it also brings to the conversation, which is something that the court has said repeatedly, the separation of power issues. And how do they then begin to navigate this one as the apex court as well?
Well, the process was a legislative one. We did see that play out. We did see consulting take place. But of course, I mean, you can't ignore the fact that when it was signed into law, there was a big amount of pressure regarding that bill and when is it going to be signed into law. So a lot of areas and electoral reforms will take time and will go beyond 2024. And it's quite evident in this case that this would be the case. And then, of course, Justice Tarrant did raise, as I said yesterday, that the Court is almost being placed in a position where they have to impose an electoral system on South Africa when Parliament has already chosen the electoral system that we're going to go ahead with in 2024. So it places them in a difficult position because they have to decide or determine matters on issues that we haven't seen playing out yet, and we haven't actually finished those electoral reforms to see that all those who have a right to contest elections can do so in a manner that is free and fair and constitutional.
What happens now?
Well, judgment has been reserved, and we can appreciate that it was an urgent matter, and we should be expecting that decision or determination from the Court as soon as it's ready.
I must say that it's comforting to have you here to navigate us through some of these, legal, arguments here, because certainly there's quite a lot, to unpack, especially when you think about this particular matter and what it all means. And Canny, before I even let you go, one of the big issues is that you and I were talking about this yesterday, but it came out again today by the IEC to say whatever decision is made, it must be as speedily as possible, because we could see it impact the very election that we are waiting for as South Africa when it comes to 2024.
It's the practicalities of the relief sought by the applicants. Let's say they are successful, then how do you do that recalculation? How do you do that split? And if they are successful on the 15% threshold, then it lowers the threshold, and then you have a considerable amount of voters or new entrants onto this voters roll, or voters ballot rather, if I could put it that way. Then what are the voters dealing with? Will they understand the process? Will they know how to vote? Will be dealing with someone compared it to a Bible of choices in the 2024 general election. So there's a lot for IEC to do ahead of that determination, if it is decided on before we head to those 2024 general elections. We know that next year they have to happen on a date announced by the president. We don't know yet, but we do know that next year we will head to elections, and a lot of those amendments are being challenged in the Constitutional Court.
And it'll be interesting to see if these amendments are put to book and we now know how the election is likely to unfold, or are we going to see yet more challenges in this particular regard in the road to the election. But Canny, thank you so much. It's always a pleasure. That is our senior reporter, Canny Maphanga, was watching the Electoral Amendment Act challenge in court for us, and we'll continue to bring you more on this story.